Hi, Courtney. It's so great to see you again. It's been a while.
I know it's great to see you too, Lori. Thank you so much for the invitation.
Oh, you are so welcome. I've been looking forward to this for a while.
I have been too, and I was just so pleased to have you invite me because what an exciting way of getting people information and helping people understand so many different aspects of aging and real estate ownership and everything.
Yeah, I was talking to a friend today and I said, she knows that I've done like five of them so far,
Yeah.
different interviews with a number of different people in different occupations. And I said, yes, we were playing pickleball this morning. And I said, yes, today we're going to talk about probate. And she's like, I don't even know what probate is. I said, well, you better watch the video then.
Exactly. Some people know exactly what probate is because they've been through it with a loved one,
Mhm.
and some people don't know what it is.
Right. So, want to introduce Courtney Sebo Savica, and she has her own law firm here in Rochester. So, if you can tell us a little bit about your background and what is probate?
Sure, absolutely. So I'll start with my background. I grew up here in Rochester and graduated from John Marshall High School. I then moved out to the cities and I went to the University of St. Thomas for undergrad. And then I went to law school at William Mitchell College of Law. And then I actually practiced law in the Twin Cities for a number of years. I lived in the cities for about 20 years and then moved back to Rochester in 2018. So I've been back almost 7 years. So I have my own practice and I have a new associate who actually works with me, which is very exciting.
Oh,
And
congratulations.
thank you. Yeah. We practice primarily in the areas of estate litigation, probate litigation, which includes contested probate matters, and guardianships and conservatorships. So it's a lot of courtroom work and a lot of litigation is what we call it. And also I do some estate planning. I've actually done estate planning and estate litigation for about probably 8 years now. After
Okay.
law school, I clerked for a judge at the Minnesota Court of Appeals, and then I worked at a couple different law firms, and then ever since have been really focusing on this particular area.
Okay, well, thank you.
Yeah. And then in response to your question about what is probate, so probate is a court proceeding. It occurs when someone dies, and it applies to people who have either no will or no estate plan at all, or to people who have a will. So a lot of people are confused by that. A lot of people think, well, if I have a will, I don't need to go through probate. Actually, you do need to go through probate. If you have other types of estate planning documents, you don't have to go through probate. But a will or no will, you do. And it's a court proceeding. And that means that you have to file documents with the probate court or the district court, the probate division. And then the court will set a hearing, and at the hearing, you will appear, and that kind of sets the whole administration in progress at that point. And then after that point is when people can sell real estate or they can make distributions from the estate and they can do what they need to do to wrap up the affairs of the deceased person.
Question for you. Um, you had mentioned if you have some documents, you don't have to go through probate. What would those be?
Sure. If you have a revocable trust, or an irrevocable trust, any sort of a trust really, your estate is not going to have to go through probate if it's properly funded. And I can talk about that later, but also if you have assets that have a beneficiary designation on them or a payable on death designation, or if you have a transfer on death deed for real estate, Those are all documents that are going to ensure that your estate does not go through probate. And to back up just a little bit, your estate will go through probate if you own assets in your name only. So if you own, for instance, your home with a spouse, and you own it as joint tenants, which is the most common way of owning a
Mhm.
house when you're married, then when the first spouse dies, the other spouse will inherit that house automatically. So a probate proceeding would not be required. Then
Okay.
when the second spouse dies, if they don't have that transfer on death deed, then a probate proceeding is going to be required.
Okay.
And probate proceedings, at that point, it can be a little difficult because if you're looking to sell the house pretty quickly after the person dies, you could have to wait a good 3 months if you're going to have to go through probate. There are some ways where you can get in more quickly. You can kind of get that emergency
Mm-hmm.
probate petition done. We call them special administrations. But for the most part, you'll have to wait to, usually people hire an attorney, the attorney drafts the documents, they get them filed
Mm-hmm.
with the court. The court schedules a hearing for about 2 months later. The hearing takes place, and then in some probates, in informal probates, you have to wait 30 days before you can sell that real estate.
Okay.
So, yeah, so it can be quite a process.
Mm-hmm. As a realtor, I understand.
I'm
I've been
sure
in the
you've seen
middle
it
of
all.
some of those situations.
I'm sure you've seen it all. Yeah,
Uh-huh.
yeah. And it's hard, right? Because I mean, real estate is a major asset for a lot of people. It's
Mm-hmm.
their most significant asset.
Right.
And there are a lot of moving pieces to selling a house, and there are a lot of players, at play, people who need different
Mm-hmm.
things, the buyers, the sellers, the closing agent, the realtors, the financiers, the banks.
Mm-hmm.
It's a lot to coordinate. So if you have to then add to all of that mix, probate court, it's not fun. And so that's why I typically recommend that people either put their homes into a revocable trust,
Okay.
and you can talk to a lawyer about that, or they
Like
do,
you.
you like me, or they do a transfer on death deed, and the transfer on death deed will then ensure that a probate proceeding is not necessary. Now, the only problem with a transfer on death deed is unless it's going into a trust, and if it's going into a trust, that's great. But if it's going directly to children, for instance,
Mm-hmm.
it can be a little bit dicey if you've got more than one child. If you have one child, it's perfect. Transfer on death deed, just give it to that one child. There's probably not going to be any concern. But if you have, for instance, two, three, four, they will all own a piece of that property. They will all have to
Mm-hmm.
make decisions together about what to do with that property, whether
Mm-hmm.
to sell it, who to use as a realtor, how much to sell it for, whether to accept one offer over another. And then also in Minnesota, every owner of property, before they can transfer that property to another person, has to have their spouse consent to that transfer. So if
Okay.
any of these children are going through a divorce or, aren't in a good relationship, etc., it can cause a lot of problems in the family, and it can really hold up. If one child really needs the money, and then another child's going through a divorce, it can just really hold things up for a long period of time.
Right.
So transfer and death deeds are great if they can be kept simple.
Mm-hmm.
Otherwise, a revocable trust is the best option.
Okay. Yes, I've run into, actually, it's kind of funny. Most families, some of them are well-to-do, and there's always that one child,
Yes. Yes,
and they're
exactly.
broke,
Yeah, right,
and they want so much money for the house. And
right.
no matter what you tell them, you show them all the evidence that it's not worth that much, they still want that much. And that's when the siblings,
Yeah. It's
that's
hard. It's a hard area to be in because how much is property worth? It's only worth what someone will pay for it,
Right.
you
Exactly.
know? And the longer it's on the market, the less valuable it's going to be. And,
Mhm.
so yeah, it can make it really difficult. So that's why revocable trusts are a really great option because
Okay.
what you can do is then you just have one person who's in charge of making all the decisions about the property. And that
Okay.
person is a trustee. So they have a fiduciary responsibility to act in the best interests of the estate and of all of the beneficiaries. And that one person then deals with the realtor, goes to the closing,
Hmm.
signs all the documents, does everything they need to do to get it makes the decisions. So if two of the kids want one sales price and the other one wants an astronomical one, they can say, sorry, two against one, things like that.
Yeah.
Yeah.
The other question I had was, it might be a hard question to answer, but what's a ballpark on what it would cost to create a trust?
Create a trust. It depends. It depends on number one, if it's a married couple. If it's a married couple, typically you do double the price because you're doing twice as many
Okay.
documents. Um, Most attorneys, almost every attorney I know, will draft not just a revocable trust, but they'll do what's called a pour over will, which is a safety net, and it kind of catches anything that you forget to put into the trust.
Okay.
And then they'll also do healthcare directives, powers of attorney, and other associated documents. And, you can't just create the trust, you also have to fund the trust. Usually, what a lot of attorneys are doing now is they're funding them upon death. So they're doing the transfer on death deed to the home into the trust. And then
Okay.
they're doing, retirement assets or life insurance policies. They're doing those on beneficiary designations into the trust. And
Okay.
then, so if you're going to do a plan like that for a married couple, it could start around $2,000.
Okay.
Some attorneys might be a little bit less expensive. And then if there are some particular, some unique circumstances, like you're a business owner or you have a taxable estate, you an estate worth more than $3 million, then the price could increase.
Okay.
So, yeah.
Well, thank you. You've done such a great job in enlightening us, and I'm sure
Oh,
a lot of people will get a lot of information that they've kind of had in their mind for a while. I have one more question. At
yes.
what age should somebody consider getting a will and putting it in a trust?
That's a great question. You know, I it kind of depends. I mean, we never know when
Hmm.
we'll need it, right?
Right.
So, I mean, probably we should be doing them really when we first buy property.
Okay.
Because when you own property, that's when your estate is going to have to go through probate when you die. A
Okay.
lot of people come in when they've just had children. That's a very common time for people to create estate plans. And then a lot of people who have children who are a little bit older, maybe they're in college or just out of college. That's
Hmm.
another very common time for people to come in to do estate plans. But yeah, the goal is to get it done before you need it, which is
Okay.
hard to know.
So I need to tell my clients once they close on their house that they need to talk to somebody like you.
Yes, yes, definitely. Yes, because they will want to make sure that they do protect that house from having to go through the probate process because it's not necessary,
Right.
right? Yeah.
Well, thank you so much to
Of
spend the time
course.
with us this morning. And
Thanks for asking me. I
anything
think
else you
it's
want to
wonderful.
add?
No, I just wanted to say I think it's wonderful that you're helping educate people. This is great. A lot of people just don't know, and it's hard to Google answers to these types of
Hmm.
complicated questions.
Right. And I find that most people don't know.
Yeah,
That's why
great.
I could not wait to talk to you about this.
Good, good, good. Well, I'm always happy to talk. So if you ever have any other questions or if you have more questions and you want me to come back, I would be thrilled.
I would love that.
Well, thank you.
Okay, thank you. Take care.
You too, Lori.
Thanks.